This proceeding of the India Media versus SDPL.
The assigned matter, that one.
Yes, my lord. Now, my lord, the respondents, the applicants there in section 34 are creating all sorts of obstructions in complying with my lord's order.
Why?
So therefore, my lord, we filed a contempt application before my lord.
Okay.
May it be listed at the earliest convenience of my lord, my lord.
My lord, may I be permitted to mention, my lord, item number 51.
It will be listed when, my lord? Next Friday?
Wednesday. Wednesday read matters. Civil matter. Wednesday 10th.
I'm deeply obliged, my lord.
10, 2 p.m.
Wednesday 2 p.m. I'm deeply obliged, my lord.
I don't know.
I need not serve because this is the first time contempt application.
Yes,
Will be issued.
After hearing, yeah. My lord, item number 51, my lord, this matter was appearing in the top. My lord, it was hard, my lord. It was made part hard. After it was made part hard, it has come under the heading part hard matters at the bottom. But can it be updated, my lord, at the top? Because, my lord, this is that matter where with settlement.
Payments have been made, settlement has been done. Lordship, remember that. CBI.
Under heading part 30, topic. Under heading part upgraded matters. Topic, upgrade.
My lord, may I permit to mention for extension of interim order, my lord? Extension of interim order.
Yes, please give it.
Grateful, my lord.
My lord, upon notice, I am mentioning for inclusion hearing, my lord. Upon
Which
notice,
matter?
my lord,
Which matter?
read matter, my lord.
Read.
My lord, may I please be permitted to mention a matter of contested application, my lord?
Contested application.
Grateful.
Have you served the copy to the other side?
My lord.
Yes.
My lord, same prayer, my lord. The revision application, my lord, it will appear under
Which
heading
year?
25, my lord, 2025. Earlier it was heard, my lord. Direction was there to serve the copy, my lord. We have served the grateful, my lord.
On that is item number 1.
Considering the submission and argument of the learned counsel appearing for the respective parties, and upon perusal of the record, it would be very difficult to accept that there was a prima facie case before the trial court to proceed with the case and take cognizance of the offences as alleged. No case has been made out against the petitioner. The continuation of such a case or proceeding, which has been pending for about 33 years, would be an empty formalities. Even if this court allows such proceedings to continue, the convictions would be remote and rare, and further it would be an abuse of process of law. Consequently, it appears to be a proper case where this court should exercise its inherent power under section 482 of the Code of Criminal Procedure. Accordingly, CRR 1050 of 2012 is thus allowed. Connected pending application, if any, are also thus disposed of. Consequently, proceeding being GR case number 783 of 1992 is quashed insofar as the petitioner is concerned.
Grateful, my lord.
Item number.
Judgment.
Considering the arguments of the respective parties, this court finds both the courts below or in allowing condonation of delay without affording an opportunity of hearing to the petitioner oblique accused. Accordingly, this court finds it necessary to intervene in the exercise of power under section 482 of the CRPC to prevent abuse of process of court and to secure end of justice. With above observations, CRR 815 of 2024 is thus allowed. Connected pending application is also thus disposed. Let a copy of this judgment shall be communicated to the learned court below for information and further directed to decide the application for condonation of delay filed by the complainant oblique opposite party seeking condonation of delay, if any, afresh in accordance with law after hearing both the parties.
Grateful, your lord. Grateful, your lord. Now we are still for the prevention of oral option.
Item number 4.
My lord, your lordship's order dated 18th of September. এসছে রিপোর্ট এসছে কে আছে সন্দীপ তো পাতে করিয়েছে
The matter was disposed of.
that one in the court, lower court below during the pendency. So that record your lordship had called for to ascertain whether it is genuine or not. That is why, my lord, to let a report be called from the trial court.
Sir,
Anichi's report.
Register.
And register, my lord, registry of the court is directed.
Actually, that record is lying in the record room. That's why the trial court could not send it.
Because this application has become infructuous, but we don't have that document to show because we are not getting certified copy from the court.
So what do you want now?
I really don't know, my lord, what to tell you, lordship. From the record room, can't it be
No.
retrieved?
Already your client has already pleaded not guilty. Pleaded guilty and disposed of.
That's before the lower court.
Accused person has pleaded guilty on 9th October 2012.
That is what I'm saying. So it has finished.
So which case, who are the accused?
My lord,
How
these,
many accused persons?
my lord, two.
Two. So who has pleaded guilty?
But I wouldn't know anything, my lord. Who has surrendered?
No, how many? Do you have the CD?
Nothing.
Do not have CD.
Sandeep Chakravarti is appearing. Kindly make it a short passover and inform me if you have.
At least one advocate should be there for along with the CD.
I'm just informing him.
The case, I'm not getting any cooperation from the state. CD lying with them, they are not appearing. Each and every case is very difficult to tackle the situation. At least CD be produced here so that I can.
Sundeep, 4 numberটা ওই যে সিডিটা
How many do you have the CD?
No, not today, madam.
So matter is appearing. Why you have not collected the CD?
We have lost the brief, madam. That is the difficulty, madam. That is why we failed to.
Now the trend is losing brief is very high.
comment.
Give us 7 days time, madam. Only 7 days.
Oh, when will
In
give it next
division
Friday?
bench also I heard lost brief. Now your case gone now.
No. Madam, 7 days time may be given.
Well,
Madam, we will
well,
bring
Friday,
Madam, we
next
will-
Friday.
We will bring out the brief as well as case study.
That matter is a, my lord, legal aid matter, my lord. That matter, the original file lost. Because on May, I have made a complaint before the administration. Thereafter, my lord, department asked me to file the copies of the petition and affidavit in opposition.
Whether any order has been passed for reconstruction?
My lord, I have been asked by the department that there is a order.
Where is the order? Do you have any copy of order from?
No, my lord, I have no copy. And after that, my lord, I have mentioned the matter before the honorable court. The matter has been sent to the courtroom number 7. The matter was in the list in September monthly list.
Maybe, but without reconstruction.
My lord, that has
without
been
order of
reconstructed, my
construction,
lord. Only a formalities have to be completed, my lord. And in this matter, I have nothing to do, my lord. That may be regularized, my lord. The petitioner is suffering from 7.
1 minute, please. Have you made any prayer before the Registrar General?
Register administration, I have made the complaint. There is the letter.
What happened thereafter?
Thereafter, my lord, the department asked me to file the copies of the.
Department will not ask you to file without direction.
My lord, that I cannot.
Ultimately, one report.
My lord, I have
must be come
submitted all
from
the.
the registrar that no, there is no possibility.
Might be
of-
there, my lord. I cannot find there, my lord. Because I have even I endorsed the my lord.
Only report is there that
I have,
tracing.
my lord, that may be regularized, my lord.
Until and unless a final report comes before this court, how court can direct for reconstruction?
My lord,
There must be a final report that no case record.
my lord, I have made a complaint because if
Under to be mentioned, eh?
And I am for the petitioner. My lord will remember that matter where I am appearing on behalf of that unfortunate auction purchaser, my lord, who has been being used.
I have already heard this matter now. Now state,
Yes, sir. You have said that yes, it's just, it was there, your lordship, please.
because this matter is listing since long.
Yes, my lord. And only one point, my lord, I would like to point out. If my lord be kind enough to take page 101.
For what?
Well, page 101 is the order passed by the learned trial court by which my Naraji petition was dismissed. And my lord, there was a categorical observation made by the learned trial court that in terms of section 13(6) of the act, the present auction purchaser had acquired right in the property and it was wrong for the bank to transfer to section 13(8) of the act. Further, the learned trial court, my lord, had dismissed my petition, my lord, by wrongly appreciating the contents of the case diary, in as much as the learned trial court had found that there are materials which suggest that the entire money has been refunded, my lord. In my most respectful submission, the money was not refunded, my lord.
Do you
And
know
my
about the Surface Act?
And my lord, one second point.
Until and unless the final sale executed,
I deeply bow down before your lordship.
then the
I-
borrower can be allowed to
I redeem it.
repay their entire amount and mortgage may be.
But here in this case, the settlement there was no redemption, my lord, in my most respectful submission. Whatever compromise and settlement was made was in teeth of the order of status quo, which was obtained by this auction purchaser from the debt recovery tribunal.
As per your contention that they have conspired themselves.
My lord, if my lord permits me,
Not only I have conspired with the bank and I am protected by a order of DRT which is been challenged in DRAT. DRAT was
Matter is
also a
still
party
paid.
to the conspiration and then before High Court where Justice Sanjeev Banerjee has confirmed it, all were party. If this has become, then we all will become party.
So
no, if my lord,
I take my learned friend's
I have
submission as
already
student
heard you in length.
if my lord permits me,
No, I have already
My lord.
heard you in length.
just one point, my lord, which probably I have missed, my lord, to show my lord the order of status quo which was passed by the debt recovery tribunal on 6th of October 2010, my lord. And on the same,
Without going there, you have lodged a criminal case.
no, my lord,
Whether this criminal case lie in this case,
my lord, may I place section 409, if my lord so
whether
permits?
you have received your money or
No, my lord, we have not received the money. There's a categorical statement. My lord had also called for a report from the bank to show as to how money was refunded. The bank has merely relied upon a letter that we have sent this check and draft to the auction purchaser. My lord, that letter dated was of 28th December 2011. Now, subsequently, when the matter appeared before the coordinate bench on to
you do not receive, you take your recourse.
Filed a suit for recovery along with damages.
Recourse from
my
civil
lord,
suit
what I
or
am,
whatever.
my lord, what I am before your lordship that the bank.
Just I only want to know that whether you have received or not.
No, my lord, we have not
That is
received. my
the
lord.
additional ground. If you have received the money,
No, my lord, we
then
have.
what remains?
So that is the ground, my lord, I have taken that the learned trial court has
Other
wrong.
side is not there and CD is also not
Lord, may-
there. I am keeping Passover.
If my lord can keep it, my lord, on next Wednesday, my
No,
lord,
no, no. This matter
I can come
cannot
with a
be
list of
kept
dates.
pending.
I am for the de
No,
facto
This
complement.
this
I will
case
also-
already I have heard on many occasions. Only CD if there. Yes, madam comes.
Last day, my lord, I had
Mhm.
showed your lordship that the CD was not required in this case, my lord. My lord, I had taken your lordship to the CO.
I mean de facto complement.
No, I had asked for you to report that whether money has been received or not.
Yes, my lord, kindly seize page 95 once. My lord, well, another CO is pending before this Honorable High Court, and my lord, an affidavit has been signed by the UK bank. My lord, kindly seize page first 94.
94 of the revisional
Read petition,
application.
my lord. My lord.
Revisional application.
Yes, my lord.
94, yes.
The bank now
Yes.
confirms that though a check or pay order was posted to the petitioner did not encash the same and the money is still retained with the bank. Now
So-
they had, my lord, sent it. Now the bank should file an affidavit to that extent, my lord, affidavit as to how it entered into the compromise with the borrower with, my lord, such and such. Now, my lord, kindly sees the next page.
So that CO is still pending.
No, my lord, still, my lord, it has been heard by my lord Justice Chaitoli Chatterjee Das, and the final order is CAV.
He's
CAV, my lord.
same time. How, my lord,
This is different.
bank,
That is civil matter,
Yes,
civil matter, he can proceed.
where
There
is
is
the
no
criminal
problem.
liability of the bank in this case, my lord? I fail to understand. My lord, the bank has given the check. What he has come up is for the
Narazgi petition.
against the order. My lord, two courts have held that due to the DRT's proceeding.
No, no, whether
pursuant to
FRT was filed? FRT was
the-
filed. Why
yes,
Narazgi-
FRT was filed.
FRT was filed.
Yes, my lord.
Okay.
Civil in nature.
My lord,
Hearing
may I rely upon
concluded,
one judgment, my lord, so permits.
Yes, you can give.
Now, upon the proposition that even in the absence of the confirmation of sale on the DRT proceeding, the auction purchaser has acquired right in the property.
If
Now,
you
this,
acquired right, you go before
my lord, may I hand over this
Supreme
judgment?
Court.
My lord,
Why you are lodging this type of
my
complaint?
lord, only contention is that, my lord, may I hand over?
With the allegation
I'm sorry, my lord,
that
it's
they
not
have
stage.
conspired.
If
If,
my
if
lord,
every bank employee will be conspired,
no, the thing is that,
everybody will be accused.
my lord, the thing is that, my lord, once they have sold the property in favor of the auction purchaser, my lord, they could not have settled it. My lord, there is no redemption. But according to their own statement, my lord, they have done a
Okay,
compromise.
I have already heard.
Court has heard this extensive.
Yes, yes. I remember this
Yes,
each
ma'am.
and every facts. This could always allow everybody to submit.
Lordship has heard and Lordship has, if, when,
And you can submit if you additional submission.
only I will take by much 3 minutes of.
Yes, yes. You can take 5 minutes also.
Lordship, kindly turn to page 95 of this.
95. নামগুলো নিয়ে নেবেন হ্যাঁ Yes, 95.
But this is the CO which they said is under CAV now. This is an interlocutory order passed by the divisional court. This interlocutory order has not been challenged by any of them. So now I will place this order. Pursuant to the order dated 14 November 2014, an affidavit has been filed by the bank from which it appears that by later dated such and such, the bank has informed the petitioner herein of the compromise between the bank and the constituent. By such letter, the bank has made over a pay of 17 lakh representing the deposit made by the petitioner auction purchaser and also returned the unencashed check of this. So 52 lakh was unencashed, which they said, and 17 lakh, they said it has been returned. So they have a knowledge that this has come to an end and the money claim, so far as the money claim is there, on November 2014, they have come to knowledge of this.
No, even if I for the sake of argument I accept bank has not paid, even then whether criminal court can ask to pay.
You know, now Lordship kindly see,
Yes.
now the page P2, which is at page 67.
Yes, 67.
Can you see? This particular says, in terms of this, the borrower having repaid this such and such, the borrower purchaser generally is hereby cautioned that with the property and dealing with the property will be subject to the charge of the UCO bank such and such and such and such. So Lordship, when they were, this is the notice.
Possession cum sale notice.
Yes. So Lordship, when they were putting into auction, inviting the bidder, Lordship, the tenderer was put to knowledge that the title is, the clause on the title is with the bank. And as it is, where it is, where it is, this is given. And Lordship, 13 says, section 13 of Surface Act 8 says that the borrower has a right for redemption of the property, release of the property, repayment of the property, till the sale certificate was.
Yes, yes.
Now,
That's
Lordship,
why I asked him
Now,
about
Lordship,
the
kindly
surface
see.
here.
Now, Lordship, kindly see the order of DRT. Kindly see the order of DRT.
No, what is the stage now? You have already redeemed entire amount, entire mortgage property.
Yes. And not only that, third party interest has been created because the water has flown. Now, Lordship, kindly see page 75 and 76.
Yes, 75.
26. Order dated 6/10/2010. According to the previous order, the sale cannot be confirmed till disposal of this application, and now the learned advocate appearing for the auction purchaser who has filed this application to treat purchaser as a party to the proceeding, the objection has to be filed to the application and the same. So Lordship can find, even though after payment he wanted to be a party, the civil court has decided that it cannot be because there was a restraint in the auction.
Okay.
Only this. I'm giving it.
May I give short reply if Malo permits? If Malo
Yes,
permits.
you can.
I'm sorry for the.
If Malo permits.
Don't waste time, sir.
No, if
Yes,
Malo
please.
permits. Only page number 76, page number 77. I just want to show my lord the order of status quo. My contention is that the bank has not allowed the redemption. Bank has settled and compromised in the violation of status quo.
Already heard
My
that
lord,
you
that
have
is
made the submissions that there was a status quo.
status quo. Despite that, my lord, settlement was made.
Yes. Okay.
Grateful. my lord.
Status quo on sale, not on compromise. I'm sorry. I'm leaving. I'm leaving.
Next.
Extremely grateful.
Seven, my lord, I am appearing for the petitioner. My lord, in this matter, my lord,
Why it is to be mentioned?
because my lord, earlier occasion has submitted that the settlement talks were going on. My lord, the matter has been settled. The dues have been cleared. My lord, the company has issued a no objection certificate, the agreement of settlement, as well as the payment receipts, my lord. My lord, I will only pay, my lord, cautious.
Section. All are compoundable sections.
Yes, my lord. My lord, 406, 409, 415, 420.
Yes. Do you have any instruction?
Yes, my lord. My lord, this is the agreement of settlement.
Now, what do you want?
No, my lord,
You want to withdraw?
no, my lord, case be quashed because my lord, we have paid the nothing remains. My lord, if the opposite party number 2 is
We received all the payment manual.
because my lord, what I'll tell you the practical problem. My lord, even if this is
Case relating to loan.
yes, my lord.
Loan.
Yes, my lord.
Loan.
My lord,
Millet, item 8 is seeking for short passover. Millet, I'm led by Mr. Chatterjee is on his legs. Millet, 5 minutes passover.
I think today it is not
Yes,
possible
but
to
only
take.
the information that I have indicated to your lordship, the charge sheet is going to be filed. They have child on 3rd December, it has been filed. The entire charge sheet along with the documents, but they can take this point before the trial court and come back.
Millet, I'm led by Mr. Chatterjee. Millet, kindly grant me a short passover. If that be the case, Millet, let him appear and.
Last occasion, I also
Yes, but that your
indicated
lordship has
him
already
that
indicated.
you take his steps before the trial court.
Absolutely. He will get much more benefits over.
Millet, I
Get one another forum.
Millet, very.
After, if you
Millet,
can come, you
Millet, can that order be passed in the presence of Mr. Chatterjee? Millet, 5 minutes passover. I'm only seeking.
Okay,
Millet.
Passover.
Passover, Millet, passover.
Ask him to come.
My lord, I'm
immediately. Otherwise, today you know.
My lord, 5 minutes passover.
2:30 matter.
Led by Mr. Bhattacharjee, my lord, I'm praying for a very short passover of 15 minutes, your lordship.
No,
Kindly,
no,
your lordship.
already I have heard Mr. Bhattacharya. Now other side, if
My lord, I'm for the opposite party.
yes, opposite party.
Pray for short passover.
No, no, I will not pass over because it is fixed at 2:30.
Mr. Shortage will
Now 2:37.
He's on legs, my lord.
He's on the way.
My lord, he's appearing in another court. my
No,
lord.
no.
Short passover, my lord.
Then I will dictate order.
My lord, kindly. My lord,
No, no,
5
kindly. What kindly? I have already fixed this matter.
My lord, 5 minutes passover, my lord.
In this way, I cannot adjourn the matter.
My lord, he's coming, my lord.
Please ask him to come.
Madam, for the
Yes.
My lord, the petitioner herein came up for quashing of a proceeding under section 420, 406 and other provisions of law.
Yes.
My lord, the genesis of the argument that has been canvassed by learned senior friend is that the genesis of this transaction originates from a commercial transaction, basically a loan transaction, wherein the person at this complainant entered into an agreement of a financing a sum for a dresser, which was financed, and ultimately, after making some installments or paying some installments, they have defaulted in making the payment. And there was a second arrangement with another company who has purchased or taken away the responsibility of this loan. And again, there was a default. So basically, the nature of the transaction being a commercial in nature, the initial deception of the initial inducement part was missing, and as such, a charge of 420, 406 is not made out. My lord, the next argument my learned friend has advanced is this, that in the petition of complaint, we have made a statement that so far as the loan advanced to this petitioner has substantially been paid, and as such, it does not attract a charge of 420, 406. Now, my lord, if your lordship sees the petition of complaint itself, although it has been placed before your lordship, now, lordship, I will draw your lordship's kind attention to certain paragraphs of the petition of complaint. If your lordship kindly come to
Yes.
paragraph 7. In the said agreement, it was also categorically mentioned that if the accused person defaults in making payments, the complainant company shall be at liberty to take back the physical possession of the asset so financed. Because, my lord, this asset was a hypothecated asset. The loan of hypothecation is this, subject, as your lordship knows, that the assets or the ownership will not be transferred completely to the person till the repayment of the loan. So during this interregnum, they are supposed to make the assets available to us for the purpose of inspection and for the purpose of repossessing or for other legal courses, if any, in case of default. Now, my lord, once they made the default in making the payment, this person came up with a proposal for restructuring of the loan with a company which is his mother concern. This complainant, this company ultimately merged with the KSR Marines.
So earlier there were three loans.
There were
three loans.
Ultimately, it comes into one loan. Earlier, there were three loans in respect
have
of
granted three loans. First loan come to the paragraph 5 of your complaint.
My lord,
There were three agreements.
three agreements.
There
My
were
lord,
three agreements.
Three agreements.
The first loan was 30 crore.
The second one is 3 crore 52 lakhs, and the third one is 23
Third
crore
one
41.
is 23 so and so.
So and so.
Now after compromise or whatever may
This is not a compromise, Miller. That is where I am in.
Exchange rate fluctuation was given. What is the exchange rate fluctuations?
Miller, your lordship is reading in paragraph.
Paragraph 5, first, second, third paragraph. Loan financing amount.
Loan financed amount was 30 crore, 3 crore 52 lakhs, and 23 crore 41 lakhs. Because Miller, there was two dresser.
Yes.
There was two. There were
one
two
purchase from some another country.
Another country and another from India.
Yes, one from India. Yes.
One from India. So there were two dressers for which there were three loan agreements. My lord, these loan agreements, initially, although there were three loan agreements, but the transaction is the same transaction. It's not the transactions are different. Only since there were two loan.
What is exchange rate fluctuations?
This exchange rate fluctuation, because since there was a foreign treasure, so there was a transactions on that. So that was
exchange
the
rate.
exchange rate fluctuation.
So altogether these are the loans.
Altogether this was the amount.
Thereafter,
kindly come.
The installment was 46 monthly installment
of rupees 88 lakhs 84,600.
One. Another one is
11 monthly installments for 34 lakhs 61,700.
And last one
56 installments for 95 lakhs. From installment 1 to 2, and thereafter there was a reducing of the installments, which was rupees 85,200.
So out of those, how many installments they have paid?
I need to, but I had asked for them, but that is very few. Very few. The difficulty is, if your lordship kindly come to paragraph 13, that is where they are actually harping on.
Please tell me how much money they have paid.
That instruction I have to take.
You come to the paragraph 12 of their revisional application.
Yes, Millet. That is where I am coming in, Millet. Paragraph 12, paragraph 13.
They have given an amount. You see paragraph ground number 1.
Ground number 1?
Yes. Page number 12 of their revisional application. They have already paid, I think, 5 crore 54 lakhs.
50 crore 54 lakhs 53,099.
So,
Malad, kindly see the breakup. 2 crore 95 lakhs 62,918 is the amount they paid.
Plus
and
47.
This 47 lakh is the amount that is a book adjustment. The moment this loan was transferred from Akash Marine to KSR Dredgers, KSR Marine, this KSR Marine also has taken loan from SEI, and because of this transfer of this loan agreement, there was a book adjustment. This 47 crore is also shown as credited to the account of the Akash Marine.
So altogether you have a 50 crore.
No, my lord, that is where I am not. This 47 crore, what is there?
Even if I accept 2 crore has been paid,
my lord,
they have paid.
My lord,
you have received.
My lord.
Regarding payment, they have some installment. They
it cannot form even a sum, millet. It cannot form even a sum, millet. So, because millet.
No. Can you give me the example of conspiracy or cheating? how
Yes.
they have cheated you.
Conspiracy is, he is the person who introduced KSR. He is the person who introduced KSR in the transaction, and KSR is the person who ultimately defaulted. This 47 lakhs, what is being projected to be paid to us, as per the version narrated over here, is basically a book adjustment.
Whatever may be, but you have adjusted with the
Well,
loan.
that doesn't take away the criminality attached to it.
Yes, that's why I am saying.
That doesn't take away the criminality
Even if-
attached to it.
even
Secondly,
if-
Millard, Dr. would kindly appreciate the KSR Marine is the ultimate company in which this Akash Marine subsequently merged into.
Company
So basically,
why
I don't know why my learned friend has used the term projected. That was reflected in his complaint only.
Where I have used the
Just now he said projected.
No, I have never said it is projected.
The adjustment was
I have
projected.
never said it is projected.
Because that's
my
his
argument.
complaint only.
My argument.
No. He said that amount which was taken by another company, introduced by the petitioner's company, that due was adjusted there, and it was that adjustment was projected.
No,
if it is
so that I
projected,
never said.
so that's projected
That I
in
never
his
said.
complaint only.
I said it was a book adjustment. This is my case, sir. I have not.
Whatever may
interfered
be book adjustment or whatever you have received.
I am not misleading.
Absolutely.
No, I am not.
Please, don't argue each other.
Now, Milad, kindly appreciate there are three parts of this case. First part is there was an agreement, 1 or 2 or 3 agreements, which has taken place simultaneously.
Please come to the direct.
Malad, kindly
my
allow me to
question.
kindly
406,
Malad,
420, where is the
Malad, kindly bear me for 2 minutes, then I'll answer your
Please
lordship.
admitted facts that there is a loan transaction.
Malad, kindly bear me for 2 minutes. In this case, there are 3 parts or 3 segments. First segment is there were loan agreements which has been transacted simultaneously. That is explicit from paragraph 5 of the complaint.
And for that, they have hypothecated.
I'm coming
Number
to this.
2, they have also secured some property.
Malad, that is where I'm coming in, Miller. That is where I'm coming in.
Where is the cheating from inception?
Malad,
Where is the cheating?
Malad, today we are facing a revisional application preferred for a quashing application.
Yes.
Now, Millet, 2 things are very fundamental to this. Power of 482 cannot be restricted only to the offenses alleged in the order taking cognizance or restricted to this. If today the petition of complaint demonstrates certain offenses which the learned magistrate did not take.
That's why I am asking you. You demonstrate for me from the complaint. Where is that?
Kindly bear me for 2 minutes.
This is a court complaint.
Kindly bear me for 2 minutes. I'll try to satisfy.
I'll give you 10 minutes. Why 2 minutes?
Now, the first 3 agreements, they have defaulted after making some payments in connection with that loan agreement. Now, this person thereafter introduced KSR Marines. The entire deal with the KSR Marines was monitored, finalized, and rather supervised by this person. Now, this KSR Marines also defaulted in making the payment. Now, the book adjustment or the payment which has been shown to have been paid in respect.
You have agreed with his proposal.
Well, if your lordship kindly.
No, you have agreed that you have not denied that I will not allow you. You have allowed.
I have allowed, but kindly appreciate the palette in which it was allowed. The loan, the difficulty is, Millard, that it has been shown as a book adjustment, but the money is from the same company. It's from one bucket to the another bucket. It's not a situation that the money was borrowed from some third entity and I have received the money. I have never seen the color of the money. And now, after this transaction, lordship would now kindly come to paragraph 16.
16 of your complaint.
Paragraph 16 of the complaint. Paragraph 15 and paragraph 16.
Yes.
Subsequent to such, the said accused person in execution of their malicious
Paragraph
intention.
16.
15 and 16 minutes.
Yes.
Execution intention refused to answer to any phone calls of the executive of the stray and other also avoiding to meet the stray officials or respond the letters. Requests were being made for the inspection of the assets, but all such requests fell in the deaf ears and accused person. It has been learned that the accused person along with the others, after making criminal conspiracy amongst others and in furtherance of the common intention of all, have committed the felony of GTL with the complaint company. That to add to it, the accused person was also not found to the address was specified in the said agreement. The assets was also not found in its supposed location despite the agreed terms, and that until repayment of the entire amount of the installment. They have
created criminal offense.
They have misappropriated the asset, the hypothecated asset.
Where is that? You show. Where is the misappropriated?
They have taken away, they have removed the assets. The Lordship, this is an hypothecated assets. They cannot remove, they cannot commit any offense of mischief in respect of that hypothecated assets till the time the loan is repaid. There are two shades. One shade is pertaining to the offense of the criminal breach of trust or the 420. Another shade is the offense of mischief. If today I hypothecated an asset to a company and subsequently I, by my conduct, by removing the asset or by doing something, reduce the value of the asset or created a situation that the recovery of the loan amount become impossible.
Any machinery, there must be a depreciation.
I will satisfy your Lordship. I will satisfy your Lordship from a Supreme Court decision where the Supreme Court has categorically held.
Please tell me where they have misappropriated, whether they have sold to someone.
Yes,
where is
yes.
that?
How could I know? That is, if today,
so only on suspicion you can lodge a complaint.
Lordship would kindly appreciate. Today we are at a stage where a complaint has been filed. So basically, it is at the stage of an inquiry or an investigation. Had this been registered as a case of FIR, then the case would have been at the stage of investigation. Now, whatever questions your Lordship is asking me, these are the process to be determined during such inquiry. These are the process to be unearthed or the materials to be unearthed during that particular investigation. Therefore, today, my contention that these assets where they are supposed to keep in respect of which they are supposed to give us the informations and to update us and not being able to find out the asset at that particular place creates the suspicion that these has been dealt with otherwise which they are not supposed to do and attracts the offense of mischief.
Only on suspicion you have lost the complaint. So
that is not the suspicion.
Of the Supreme
that is
Court,
not the suspicion.
Now, just now you have said suspicious that they have disposed of
the suspicion.
So where is that?
If your Lordship kindly,
you have to specify either allege that they have sold the machinery to someone else without informing us, then the question will be different.
My Lord would kindly come.
From your own complaint, you show me where is the criminality of 406, 420.
Even, my case is not
mischief.
My Lord.
Even mischief.
My Lord, my Lord, my Lord.
Please. I have already heard you.
Yes. Unless your Lordship has a specific query, I will not trouble your Lordship.
Because I have heard you and
yes,
I
was just showing my Lord. I just complaint, my Lord. It's 420. Now it's mischief. Tomorrow it will be murder, my Lord.
My Lord, then I have to very well, my Lord. From learning from my learned senior that a complaint is restricted to the sections leveled over there only. This is a new proposition of law. Anyways, my Lord. Now, my Lord, kindly see the allegations given over there. The assets were not.
But with your Lordship's leave, my Lord, may I just, in case your Lordship has a specific query, I'll just come back, my Lord. May I take your Lordship's leave?
I do not have any.
If your Lordship has, your Lordship will let me know.
I have query only with.
I'm obliged. I'm deeply obliged.
So you may leave. Your junior is.
He will be here, my Lord. I'm deeply obliged.
If required, I will call you.
Deeply obliged.
May I continue, my lord? My lord, kindly, may I, if I place the paragraph 16 once, that to add to the accused person was also not that found at the address.
Which paragraph you are reading?
Paragraph 16. That to add to it, the accused person was also not found on the address as was specified in the said agreement. The assets was also not found in the supposed location despite the agreed terms that until repayment of the entire amount of the installment of the complaint company was supposed to be the absolute owner. My lord, this is the allegation of removing of the asset from the location. My lord, would kindly appreciate this is a case, this is a situation where a complaint has only been lodged before the landed court, where only a summons has been issued. The process is the evidence before charge, where I have to satisfy to the landed court that by way of producing materials that the case has been made out prima facie for facing the trial. My lord, even that stage is yet to reach, my lord. My lord, today, if from my complaint.
Now come to first read the entire paragraph.
On several occasions, TRAI officials has been trying to get in touch with the accused person in order to settle the matter, but all our efforts appear to be in vain since the accused person have been avoiding to respond to the sincere gestures of settlement. Requests to make the legitimate payments have fallen in their deaf ears.
So, once you are saying they are not found in address, once you are saying nothing was there, now you are requesting them.
No, my lord.
And
On
they,
several occasions has been trying to
request
get in
make
touch.
the legitimate payment have been fallen in their deaf ears.
My lord, if I,
What does it mean?
my lord, if I read it,
Your contradictory statement in your own paragraph.
my lord, if I read it for another thing. On several occasions, TRAI officials has been trying to get in touch with the accused person. So there was an attempt to thereafter in order to settle the matter. But all our efforts appeared to be in vain since the accused person have been avoiding to respond to the sincere gestures of settlement. So I had made an attempt to communicate with them, to contact them, to find them out where the assets
They were not
are.
there.
They are not.
How you can make a settlement?
Malak, that is where that shows their culpability. That not only
any other allegations?
No, Malak, this is a case of mischief and the criminal.
Yes, any other allegations?
No, Millet. That is
have any other allegation?
No, Millet. That is my case, Millet. That the case is based on the circumstance that as per the hypothecation agreement, they are supposed to keep me posted, keep me updated, and not to deal with the asset in any manner which is detrimental to this asset.
Now give me the judgment.
Millet, I will be placing the judgment. Millet, kindly permit me that. আমার কাছে তো আমার কাছে কোর্টের বাঞ্চটা কোর্টে কোথায় দিয়েছি কোর্টে তো এখনো মামলাই করিনি মামলা তো আজকে ফার্স্ট করেছি ইন্ডিয়ান অয়েল কর্পোরেশন এইভাবে কি করে তোমাকে বাঞ্চ করে সেটাই করিয়ে দিচ্ছি আমি তোমার সাইটেশন গুলো দিয়ে দেবো নয়তো আমার থেকে পরে জিজ্ঞাসা করে দেবো My lord, kindly come to paragraph. আমি দিয়ে দেবো তোমায় কপিটা এটা আমারটাই তোমায় দিয়ে দেবো হয়ে গেল ঠিক আছে
Yes.
My lord, what has fallen from your lordship is this, that once there is a commercial transaction and the party once has acted pursuant to such commercial transaction or an agreement entered between the parties, the initial deception cannot be inferred. And if this initial deception cannot be inferred, any subsequent stance or any subsequent change in circumstance cannot add this deception to the party. This is the proposition of law. Now, Lordship would kindly see the fact of this case, which your Lordship will find in paragraph 224. This is a judgment of Indian Oil Corporation, Miller, 2006, 6 SCC 736. Miller, this is a case.
Paragraph?
Paragraph 224. Rather, paragraph 225. May I place it, Miller? That the appellant entered into two contracts, one with the first respondent and the other with the sister concern. Skyline NEPC. May I proceed, Millet?
Yes, yes.
Skyline NEPC Limited, agreeing to supply to them aviation turbine fuel and aviation lubricants. According to the appellant, in respect of the aircraft fuel supplied under the said contract, the first respondent became due in sum of rupees 5,28,023,501 and Skyline became due in a sum of rupees 13,12,76,421. The first respondent hypothecated its two Fokker aircrafts bearing registration number this and this to the appellant under the deed of hypothecation dated 1/5/1997 to secure the outstanding amounts. Clause 2 of the said deed provided that the aircrafts will all parts and associates stood hypothecated to IOC by way of the charge as security for payment of the amounts due with effect from the date of hypothecation. Clause 3 of read with the schedule set out in installment schedule for payment of the amount due. Under Clause 6, NEPC India declared that it would not assign, sell, pledge, charge, underlet, or otherwise encumber or part with a possession, custody, or beneficial interest in respect of the two aircraft without the previous written consent of the IOC. Mamalad, may I pause here for a moment? The clauses that settled out over there, the clauses that mentioned over there are also identical and similar to the clauses which are the part of this agreement, because this is also in the nature of a hypothecation agreement. Now, Lordship would kindly come to paragraph number 4.
No, please come to my question.
Well, I'm coming to this.
Yes,
Kindly
directly come. I am not asking
Otherwise-
about the facts.
But if I do not place the facts of this case, I will not be able
If
to.
I need, I will ask you to.
Very well, Millet. Then Lordship would kindly come to paragraph 32.
Yes, 32.
Rather, Millet, let me start with paragraph 36. In this case, the complaints clearly allege that the accused with fraudulent intention to cheat and defraud IOC had IOC to resume supply of aircraft fuel on cash and carry basis by entering into a further agreement dated 29/2000/1997 and undertaking to clear the outstanding amount of rupees 18 crore approximately within the time stipulated in the hypothecation agreement. The sum and substance of the said allocation read with the other amendments extracted above is that NEPC India, having committed default in paying a sum of rupees 18 crores, entered into a fresh agreement dated this, agreeing to clear the outstanding amount as per the fresh schedule, with the dishonest and fraudulent intention of preempting and avoiding the action by IOC in terms of the hypothecation deeds to take possession of the aircraft. Though the supplies after 29/2097 were on cash and carry basis, the fraudulent intention is alleged to emanate from the promise under the said agreement to make payment, thereby preventing immediate seizure of the aircraft by IOC. But here I am pausing for a moment. I would kindly appreciate the situation over here. First, they have entered into an agreement, defaulted in making payment. Immediately thereafter, when I am supposed to take the legal steps against them, they came up with a proposal that, look,
Where is the legal steps taken by you when they have avoided you?
My lord,
Any steps you have taken?
They
for
have that is the complaint, Millet.
Avoiding
part is the second part.
Seizure of the hypothecated machine.
Avoiding part is the second part. It comes in the second part. I am speaking about the first part. When they first defaulted in making the payment, at that point of time, just to circumvent me from taking steps against them for recovery of the loan or for the steps available to me, they have introduced a third person that, look, this person will take charge of my loan. And who is
definitely, suppose someone unable to pay their loan.
Yes, Millet.
That may be happen.
Absolutely, Millet. I have no issue in this.
If you agreed,
yes,
then
I am agreed to that. Yes, I am agreed to that. I am agreed.
Up to that stage,
there is
you have no any.
No, Millet, nothing. But subsequent thereto, they have again defaulted in payment, and what they have done, they have removed the assets. Now, Millet, kindly appreciate the situation. At the first juncture, the inducement was to advance, and second juncture, make the recovery impossible with an inducing contract to enter into for the second time. Now, Lordship, kindly read this, kindly keep this in mind and read this judgment for one moment, Millet. thereby preventing immediate seizure of the aircraft by IOC. The allegation made in addition to the allegation relating to removal of engines has been lost sight by the High Court. All that is to be seen is whether the necessary allegation exists in the complaint to bring the case within section 415. We are clearly of the view that allegations in the complaint constitute such an offense. We are not concerned with the proof of such allegations or ultimate outcome of the trial at this stage. Now, Lord, may I continue paragraph 37, which deals about section 425, that is the mischief. The three ingredients of this section are intention to cause or knowledge that he is likely to cause wrongful loss or damage to the public or to any person, causing destruction of some property or any change in or diminishing the value or utility or affecting change in the property or in the situation thereof, or in the situation thereof. 3, the change so made destroying or diminishing the value or utility or affecting it injuriously. For the purpose of section 425, ownership or possession of the property is not relevant. Even if the property belongs to the accused himself, if the ingredients are made out, mischief is committed, as is evident from illustration D and E to section 425. The complaints clearly allege that NEPC had removed the engines, thereby making a change in the aircraft, and that such removal has diminished the value and utility of the aircraft and affected them injuriously, thereby causing loss and damage to IOC, which has the right to possess the entire aircraft. The allegation clearly constitutes the offense of mischief. Hence, again, we are not concerned with the proof of ultimate decision. Now, Lordship, kindly visualize the facts of this case, my allegations over here. Forget about the first, let us forget about the first part, that there was no intention for them to cheat us. They have entered into a second agreement with a bona fide intention to make the payment. But subsequently, when they have defaulted in making the payment, the situation was this, that we have to secure the loan, we have to take possession of the loan. Now they have removed that place, they have concealed that. So that is the situation which is sufficient to attract the penalty, which is sufficient to attract the culpability. Now, the next judgment I'll be relying upon, but I'll be relying upon several judgments. I'm not reading all the paragraphs, but 3 judgments I'll place before your Lordship, Millet. The next judgment I'll be relying upon is SP Gupta, which will be, Millet, the 3rd judgment.
Yes.
In my compilation, Millet.
Yes. Paragraph?
Millet, the paragraph will be paragraph 17.
Yes, 17.
Well, would kindly see the explanation given. That's the explanation quoted from the section itself and how it has been amplified. However, the aforesaid provision clearly indicates that if at the very inception of the negotiation it was evident that there was no intention to cheat, the dispute would be civil in nature. But such conclusion depend on the evidence to be laid at the time of trial. Therefore, the very essence of 420, that I do not have intention to cheat, that intention as per the law of the Supreme Court is a disputed question of fact, and that too in these situations where there is a circumstance indicating that their subsequent conduct indicates some malafide to their part and culpability to them.
Okay.
Now, the next judgment, which I'll be relying upon, is the Ghanasham Sharma. The argument, and it has rightly fallen from your Lordship, that this complaint is 420-406. So, whether there is any scope for traveling beyond the scope or ambit of the allegations of 420-406 or not. If your Lordship sees, this is the second last judgment I have relied upon in my compilation, is Ghanasham Sharma versus Surendra Kumar Sharma and others. Yes. Ghanasham Sharma and Surendra Kumar Sharma, your Lordship will find that in this case, paragraph 7 and 8 is a relevant paragraph. your lordship will find that in this case, the argument was advanced before the Honorable High Court was this, and the Honorable High Court has also quashed the proceeding on the ground that the proceeding is under section 420 of the Indian Penal Code. There was the charge under section 379 of the Indian Penal Code, and as such a proceeding is not maintainable. The Honorable Supreme Court has categorically said that no, you cannot do that, because the ambit of 482 is not to decide the sections in which the offense is made out, is to decide whether any offense is made out or not. And that is the principle of the cognizance, Millet. Whether I have stated a section in the complaint or not, or in 200 or not, that's not important.
Yes,
It is what is the facts narrated, whether that demonstrates any other additional offense or not. If that demonstrates an additional offense, the learned magistrate can took them into consideration and can proceed with the same. Therefore, Millet, in my humble submission in today, that the facts demonstrated therein at least makes out a case where at least a mischief or to that extent is made out, and that is required a trial, Millet. My learned senior has relied upon two decisions in support of his contention. One has been delivered by your lordship, which is Basukinath Food Processors. My lord, so far as the Basukinath Food Processors is concerned, Millet, your lordship will find that the speciality of this case, that is the second part of contract, that was completely missing over there. It was a case of simple loan transaction where there was a due of around X amount. In default of that amount, the proceeding was initiated and your lordship has quashed the proceeding. Therefore, the subsequent conduct which amplified their initial deception was missing over there, and factually that judgment is not applicable in this case. And secondly, so far as the decision relied upon by learned senior friend in the case of the Manish as delivered by the Honorable Supreme Court, your lordship will find in that case also that the transaction continued even after the first default. And this transaction, while continued even after the first default, there was nothing in the form of an agreement or undertaking as available herein that I will clear the amount if you continue the service. So the second time when they are coming with this undertaking and ultimately removing the asset and thereby unsecuring the loan, that indicates the culpability at least for the offense of 418 and that to 425. Because, Milord, it's an agreement where they are supposed to protect my interest. It's not that every cheating will lead to the punishment under section 420. There is a provision of 418, there is a provision of 421, 423 also, which protects different shades of cheating. So once there is a legitimate agreement, they have with ill-gotten interest or with culpable interest remove the assets therefrom and thereby cause the injury to us that comes within the ambit of 418 and 425.
Madam?
My lord, fix the matter on the next Friday. My
No,
lord.
no, I will not fix the matter.
Well, Mr.
Ask him to come.
Bhattacharya, 3:30, your lordship.
3:30, still there is time. Only one thing you have to answer, whether property was removed or not. Where is the property? Have you indicated in your application that your property is still lying with you?
I'll just
Any application in your application?
Mr. Bhattacharya will address to that same, my lord.
সাইটেশন গুলো নিয়ে নেবে, লিখে নাও, আমাকে সোমবার একটু কপিটা দিয়ে দেবে। আমি কিন্তু সবটাই যাই করছি, সুতরাং এই জন্য দিয়েছি, আমি এখানে পে করেছি। তুমি তাহলে আমি তোমার সোমবার তোমার কাছ থেকে নিয়ে নেবো কপিটা, তুমি জেরক্স করেও নিয়ে নেবে।
Two things I want to know after lodging this complaint, whether you have made any payment or not, or whether hypothecated machine were removed from your place or not. To be mentioned.
Extremely grateful, Millet.
Grateful, lordship.
Passover.
Item 8. Would your lordship take up the Passover?
Charge sheet has been filed. So I am disposing this case.
Your lordship only kindly records that they have submitted that they have filed the charge sheet. In view of the changed circumstances, we are withdrawing the same with praying for liberty to file afresh at the appropriate stage. And your lordship is kindly disposes it off on those terms. And without going into the merits, your lordship is
definitely.
only kindly records that.
The effect is the same, but the council goes back happy.
For your only satisfaction.
Lord, deeply. Your lordship is very kind.
Old matter, item number 78.
এই এক্সটেনশনটা দেখে দাও একটাই আছে
একটাই আছে extension.
Extension next.
my lord today it's expiring my lord I filed within time
Today expiring.
filed within time
CBI. So for the other respondent,
Item number 9.
I have served my lord come
bank is the other respondent.
Both parties are there. Where is the
my
opposite?
lord I have served affidavit of service
So for, I am applying for the CBI. lordship.
CBI is appearing
Where is the CBI?
So I have applied.
You are approved.
old matters ধরেছি
Hey, entry mode. After vacation,
my lord
this matter.
my lord
Any possibility of those matters to be taken up today? Because the lordship will treat up to 3:30.
28 and 29. Who is the other side?
I am the other side. My lord, these are those matters which
Interim order today expiring?
no, what is expiring is still there. Time
Still there. I will take up today. I think.
Very well, next Friday at 2 p.m. तो लिखे रहते 28, 29 next Friday 2 p.m.
29 and 28, 29. Yes, Resmi. এটা দেখো তো আছে ফ্রাইডে কোনো ম্যাটার ফিক্স আছে? Is there any matter fixed? ফ্রাইডে এখনো একটা করলাম না আমি 2:30 12
Yes.
whether it will be taken up on that day. Who will argue?
I will argue.
You will argue.
Either 2:30 or 3 p.m., whatever is convenient to your lordship.
Okay, 3
also.
3 p.m. Because this matter I have fixed on many occasions, so you must be present there,
But I will
leaving
complete-
other matters.
But I
Otherwise,
will complete my argument on that. Be rest assured about it.
because I only sitting half day and fixing matter again and again adjournment.
Definitely.
So I will take up that matter because I remember. I think this was started.
Yes, it had already started, my lord.
Started. Okay, then 3 p.m. Please.
3 p.m.
The next item, item 10, the man is in custody, my lord. He is suffering sentence. This is for restoration application. When last occasion matter was taken up for hearing, my lord's desire was to hear out the main matter. This is a case where my petitioner was convicted under section 325 of the Indian Penal Code for 1 year. Challenging that order of conviction, he preferred 10. He preferred a revisional application before the learned.
Upgrade করে দেবে. Please upgrade this 10.
10, it is appearing under the heading application.
Next time. Call the old matter.
My lord, I am for petitioner. Kindly make a note today. Due to supplementary affidavit he has done on last occasion and service pass is incomplete, my lord. Kindly make a note today.
When you go before the trial court, already charge sheet has been submitted.
Yes, my lord, but in last occasion direct.
Go before the trial court, you pray for discharge. If you have case, if your prayer will reject, you can come.
But my lord, affidavit, supplementary affidavit is done on last occasion, my lord, and counsel are absent today.
Where is the supplementary affidavit? Where you have?
In keep bit of Mr. Counsel, Aplok Basu, he is absent today, my lord.
So charge sheet has been served upon you.
Yes, my lord.
When? Not today.
Get for him.
Not today. Next day you bring either
Yes.
supplementary affidavit, otherwise I will dispose of this case.
Yes, ma'am. Get for
Go before the trial court and make your submission.
Get for him.
I'm for the petitioner, your lordship, led by Kallur Kumar Basham, praying for not today only.
Why old matter I will not allow?
Kind your lordship, he is engaging another court.
2015 matter. Last occasion also you made prayer.
He was ready, your lordship.
No, this matter will be not allowed. Last chance করে রাখো তো। Matter is you will not come, I will deliver the judgment.
Old matter.
The report has not been received.
My lord, I am for the petition.
81, yes. Who is the other side?
There was learned advocate appearing for the state, my lord. She's not here at the moment.
Arya Hussain. Arya Hussain. Not there. You are ready?
Absolutely.
Ask him to be present next day with CD. I have already directed.
My lord, kindly record my presence for the day. Kindly, my lord.
Not today.
At least, my lord, I can pray 1 day's adjournment in future.
No, next day I can. Yes, next. Not today, Gaurav. Not today. Da, 84 da. Dismiss for default. Second time, huh? Second time, dismiss for default.
85.
Same. Same.
$86.
Same. Second time. Can is also thus disposed of. Can 1.
87.
Same. Dismiss for default.
$89.
Unta. 89. ठीक है, not today. 90.
90.
चलो तो 90.
May I only, my lord, mention before your lordship rises, item number 12. My lord, this is the case of the Maruti company to do with the steering wheel. If your lordship remembers,
Yes, yes.
Mr. Banerjee was arguing. My lord, it's going to come up on the 12th. But my lord, the concerned officer, who is the my lord, technical officer who understands the working of the steering, my lord, he will be here physically, just in case any clarification is required. My lord, we are only praying for 19th instead of 12th, if your lordship may consider, because he's in the head office, he comes from Gurgaon.
Not need any.
My lord, we may perhaps, my lord, feel comfortable in his presence, my lord.
Who is the other side?
My lord,
He's not here.
he's not present in court
On
today.
that day, I will take a.
12th, very well. Then, my lord, 12th, we'll try and bring him on the 12th. No difficulty. Barot. Great.